Wait, no more clearance until I tell you to clear. First, we are clearing no media. And I want you, I hope you have already talked to them. So, here you are people and then we say one camp. John.
Sura. So good.
Joshua Kaketo. Margaret Zalwanga. Kolebo. Mukose. Kiraje.
Chibi.
Chelsea. Matabalwa Chelsea. Peter Sengo. Serugo. Peter Serugo.
Christina watanzia dakao.
Kayaga.
Daniel Chibeti.
Here, I'm sorry.
Ronald Galiwango. Ronald Galiwango. Swaibu Ibrahim. Jogeza Nicholas. Emmanuel Chirunda. Sulaimani Sebugwao. Mumuza Davis. Waiswa. Yengo. Mpaji. Sendegea.
Anybody else?
Just imagine I'm watching that. Young and poor people. That's too cute. Get away on the ngenda kuba Musa ndaba ngenda kukuba lulina akulaba wandize mabega wange anti kati jangu leka funzamu at least ate kati onfunzizamu nawe David tokagazia nnyo ante nene kati akange kaana basina kyendaba sisobola sina kyensobola muwe muwali ate nayo no gaya akola gani kana yes sir kyensuubira awo sisukawa lwakuba eno waliyo omusajja muwanvu addako addakewa tubadde tugenda kukyawe sigogane tumanyi nkulabye leero singa olina okumutegeererawo
Lieutenant Gifton, Second Lieutenant Regina Nazara, and we shall also be joined by Second Lieutenant Anthony Phillips. Those are the atoms for the state.
and the other counsel who is not present is Mr. Kizza Besigye. He's still counsel for the accused. Honorable Chair, honorable members, and the team representing the defendants. Honorable Chair, we have some housekeeping issues that we request to be dealt with before we proceed. If the Chair may allows. Handled by my colleague, the Lord. Starting off with the senior counsel. I apologize. I believe it is
the court. One of the housekeeping issues is regarding our right of access to the court as advocates representing the suspect in the law. And looking at regulation number 60 of Uganda People's Defense Forces Act, regulation number 1. This regulation gives you, Mr. Chairman, the duty to ensure that this court functions as any other court of law. And in any court of law, advocates are granted access to the court to be able to do their duty to represent the accused persons. Because of what transpired here last time we were here on the 10th, when Aaron Chisa was denied access and it resulted in him being jailed, we are most humbly seeking your assurances that as advocates, we are not going to endure any intimidation or obstruction as we come into court to do our duties. I must state that what transpired has caused a lot of shock. If you can see, we are lesser than we normally are. It has caused fear and intimidation among the ranks of advocates, and we thought that we needed to bring to your attention that this court needs to show and to demonstrate balance, not just the welfare of the military officers before it, but the welfare of everybody in its presence. So we are seeking assurances that we'll be able to represent our clients without intimidation. And today I must state that we have ease of access unlike other days, because we also want to be upfront. Today we have even been facilitated to sit together where we can be able to pass notes to one another. We thought we should bring that. The other issue is of officers who are manning the court not having their name tags. So we are not able to know who is interacting with us, and it is necessary because it's procedural that any officer who is officiating at the court should be disclosed. An issue that is may not appear very relevant, but it is. We have noticed the changing composition of the court, that sometimes one or two members are replaced, and we are requesting when that occurs, kindly let us know who has been replaced and the names and the rank of the person representing them. You remember that at the start of the court, the names and ranks of all members of the court were read out. But at that time, these two gentlemen were not represented. So when they change, it throws us off balance. We are not able to know the composition of the court, which is a requirement. We have other housekeeping issues which I'll leave my colleagues to add to. And maybe before he rises, to my colleague, professional colleague, the judge advocate, just to tell him that yes, I'm from Kenya, but I'm an East African and have an East African passport. So the unkind reference of me as a foreigner is not last time. It's not applicable. I'm an East African holding an East African passport. So apart from being licensed to practice law here, I come as of right being an East African. There is one other issue that I was required to mention before I hand over to the Lord Mayor. It's just about the terminologies. The last time, the judge advocate actually said that I could also be subjected to contempt proceedings for referring to this court as a tribunal. Whereas we are trying our best to keep saying court, I just wanted it to be on record, Mr. Chairman. The word tribunal is not derogatory at all. Tribunal refers to a court in the Oxford Dictionary, and I hope my team has come with a photocopy. It refers to a specialized court, like yourselves, which is dealing with a specific court, a specific matter. You are not dealing with general matters. For instance, a Ugandan who is a landlord cannot come and file a claim against the tenants before yourselves. You are set up for a particular purpose. That's what tribunal means. And therefore, I would plead with the judge advocate, please let us give the proper terminology, proper interpretation, because they are bound to take your interpretation if nobody objects. But if we object, then the court, led by the chairman, has a duty to see whether our objections are valid. So I would like to refer to the English dictionary and say...
Maybe, if I may interject, the word court is defined in the UPDF Act. We are not going to adapt the dictionary definitions. Use the UPDF Act to define what is the meaning of court. And that is the one we shall go with.
That exactly is our problem.
Which was enacted by the parliament.
It is true.
So outside that, unless you go back and start it from there.
Mr. Chairman, we seek your indulgence in listening to our objection. The English language is neither defined by the UPDF Act or even by the Constitution of Uganda. The English language is a foreign language, and the meaning is found in either legal dictionaries or reputable dictionaries in the world. And therefore, the word tribunal court, which is an English language word, must be defined. And I say Article Rule 60 places a responsibility on the chairman to ensure that this court functions like other courts of law. We actually quote those dictionaries every day. In the courts in Uganda, in the courts in Kenya, in courts anywhere in the world. And I invite you to check the word tribunal so that you do not undergo threats of being imprisoned for using the word tribunal. It's not derogatory. It can be used interchangeably. And what I'm really hinting at is that the interpretations of the judge advocate must be as closely as possible to reality to avoid misleading the court into acting in a manner prohibited by the Constitution of Uganda. I hand over to my colleague.
Thank you, Mr. Chairman and members. Mr. Chairman, just wanted to substantiate these issues with prayers. Number one, Mr. Chairman, the issues raised by senior counsel quite fundamental in the administration of justice before you, go by this court martial. From the list read by my friend here, Council Kampala, the name Kizza remains on the list as one of the applicants representing their chosen persons. Mr. Chairman, we seek your guidance on how that is going to be handled, because the instructions still stand that it should be part of the team, despite what transpired the last time we appeared here, the proceedings of the Somali court. So, Mr. Chairman, we are wondering whether there will be orders at every time the proceedings come. You have discretionary powers to mandate that he be produced here to execute the duties, and when they be his return. But we leave it to you, Mr. Chairman, to guide us on how we are going to deal with that, because it's a matter which touches on the right to representation, which is an integral part or a key ingredient of the right of fair hearing enshrined in Article 28 of the Constitution. And as we indicated earlier, there's a specific role he had been assigned in representing the accused persons. So we beg to be guided, Mr. Chairman, in how Kizza is going to continue featuring these proceedings as well of counsel. And we ask that you pronounce yourself on this particular matter. Two, again, we ask, Mr. Chairman, that you pronounce yourself on the validity of the proceedings conducted when the tribunal, rather the court martial, the panel changed. When the panel, the composition changed. Because as per Regulation 26, Mr. Chairman, the sub-regulation 1, the order convening the court and the names of the officers appointed by the accused person shall be read in the hearing of the accused, who shall be given an opportunity to object to any of those officers. Indeed, at the commencement of the proceedings of day 1, the names were read. But subsequent to that, as highlighted by my senior colleague here, the panels kept shifting. So, the panel that was announced on day 1 is the panel that ought to have continued. Even on the day Kizza was tried, summarily and convicted, it was a totally different panel. So, Mr. Chairman, we beg that you pronounce yourself on the validity of the proceedings that transpired after the panel had changed. And that is also fundamental in line with Regulation 26 of the regulations of this court martial. Now, on the question of intimidation of lawyers, it's a very serious one. We beg that you critically reflect on this. We are concerned that the war environment is not conducive for dispensation of justice. As she has noted, and we are on record, you can see our numbers are shrinking. They are shrinking because of the intimidation which is there. There are orders that were made earlier by you, Mr. Chairman, that all the officers manning the processes right from the point of entry should be clearly identified. They should have name tags. But we continue to have officers who are moved, whose face you cannot even recognize, who have no name tags. So we don't know who we are dealing with, Mr. Chairman. And this is a known practice. I can see, Mr. Chairman, members Mr. Chairman, their names were announced to us. And it's not without a reason that that provision was enshrined in the rules governing the proceedings before you. Why should we continue to have officers all over manning the courtroom here, manning the premises, handling all these the protocols here we go through? You cannot decide them. And they create the environment to be very, very inimical to dispensation of justice, and very hostile, Mr. Chairman. And this is a key tenet of the due process, and it's a key tenet of the right to fair hearing, which is the bedrock of our criminal justice system in this country. I request that, Mr. Chairman, you make the environment conducive for administration of justice. It's a well-known principle, Mr. Chairman, that justice must not only be done, but should also be seen to be done. So it should be manifested in the proceedings, in the way all the processes are conducted, and in the way we are treated. But, Mr. Chairman, the perception, and the reality is no conducive environment. And finally, Mr. Chairman, on the nomenclature here, which is turning out to be controversial, the issue of the tribunal. I thought there wouldn't be fuss about it, because we use these terms interchangeably, even in the courts of judicature. Mr. Chairman, it has happened even in the Supreme Court, to refer to the Supreme Court as a tribunal, to refer to the Chief Justice as an arbiter. And the Chief Justice does not take offense. And to refer to his office as an arbiter, or to refer to him as an arbiter, the Chief Justice does not take offense. The ordinary courts of law do not take offense being referred to them as. Now, I'm worried if that is going to invite disciplinary proceedings, just even if it's a mere slip of tongue anyway, that is going to invite disciplinary action. That sends chills down our spines, and it has a chilling effect on the execution of our duties. That chilling effect is so fundamental in the dispensation of justice. If I may ask, Mr. Chairman, I have had some of the officers here address you as your lordship. They're saying, my lord, my lord. Yet, for us, we are addressing you as a chairman. Would that also be taken to be undermining this court? That we're not addressing you as my lord? That we're addressing you as a chairman? I think the judge advocate and the entire panel shouldn't take offense about this. We can interchangeably refer to you as court, we can interchangeably refer you as court martial or as a tribunal, because they all mean one and the same thing. But one fact remains, if we are talking about courts of judicature, that's a different matter, Mr. Chairman, because courts of judicature are well defined under the Judicature Act. And that is a different matter. So if I said this general court martial is not a court of judicature, I am stating facts within the law, under the Judicature Act, under the Constitution. That is not a court of judicature. And that is a fact. So, Mr. Chairman, I beg that you do pronounce yourself on those matters, because they are fundamental on the dispensation, in regards to the dispensation of justice. I beg to move, Mr. Chairman.
My name is Samuel Mwizi-Mulinga. Mr. Chairman, I raise on two issues. First, whereas this side we had a better conducive environment this morning, the same was extended outside. Some of us have to walk a kilometer to court. Right from the T-junction you are faced with blockades. I don't know why council cannot be given access to park within the premises of the court. I believe this is one of those issues that have to be taken seriously. How do I carry a box full of books from the T-junction or in the fields where we have been pushed to park? I think this should be addressed. We've seen a large parking space up here, even the premises here. So that should be handled, Mr. Chairman. Secondly, are we duly constituted as a court in the absence of reserved members of the court martial? We need to be guided on this issue too. I'm obliged. Mr. Chairman, short one, Frederick Mupaka. Regarding what my colleagues have said, these have been using the words interchangeably, the terminology. Mr. Chairman, in our Constitution, Article 151, which is at page 130, and this touches on courts established in Uganda by the Constitution and the laws. It makes an interpretation of judicial officer. I just want to juxtapose it with the word of the term tribunal. It says in this chapter, unless the context otherwise requires, judicial officer means, under paragraph A, a judge or any person who presides over a court or a tribunal, howsoever described. It is just to lay the emphasis that the application of the word tribunal or forum is not necessarily undermining court. It is just a matter of expression. Kindly request that that is borne in mind based on its code of the Constitution, so that it is not taken to be demeaning the members of the Constitution. Thank you very much.
Let me summarize this. I'll start from the bottom. Council Mulima? Yes. This is what Council Mulima said. By the time I came, I did not even see anybody in the room. So I can't tell unless I first consult people who are managing the situation. But on that one, I can't tell much about that because by the time I passed there was nothing. But if I'm not mistaken, I may add this with intimidation. The council probably talked about. Much as you want to blame us in almost all issues, I think somehow some of you need to blame yourselves. Council Club, what you have been talking everywhere, what you are intending to do. And I think they cannot be taken lightly. Because we need security. People who come here need security. And we don't know the tactics you want to use to destroy this court. We don't know. So, security also have to check if they have been checking people who are coming. I think that's what it's all about. Because I don't know what they were asking you, what they were telling you, what they... I can't tell. But I believe it would have managed maybe from those statements sometimes you make. And on Council Aaron, I don't know really what you are pushing, because I've never had, unless JL will guide us also on that one, a person who is serving a sentence to come and attend the court, that one I don't know. Can be advised on that. Senior counsel, I don't know, you said, I don't know where this one came from. We know, of course, you are from Kenya, and Kenya is part of the East African community. So I don't know that one, where it came from. But I think even the villager, once you say I'm from Kenya or Tanzania, they know. It's good you have talked about the conduct today, and you remember it was raised the other time, and you said I want to talk to these people. And that's what we want. We are not here just to, it's not a war. And I don't know why you are looking at one side, you are not looking at another side. People making noise in the court. To the extent of even of standing on the chairs which are not supposed to sit where they are supposed to sit. Singing, is that a court? Or you want to make us, you want to, you are either provoking us or you are, I can't tell why you are doing that. What we need is to conduct yourselves in the manner you are supposed to conduct yourselves. This is a court. I've seen it everywhere. Once a council or anybody submitting, everybody is listening quietly. You finish another one. If this side finishes, another side also, so that we proceed without any problem. I don't see where can friction come from if we are following what we are supposed to. Unless, if you have, especially the council was asking about my vote versus chairman, I think the reserve members. Yes, I will take the opportunity to respond to the legal issues arising from the submissions of defense lawyers. And I will also refer them to carefully Regulation 63, which talks about the duties of the judge advocate. Sub-Regulation 1 says that the prosecutor and the accused respectively are at all times, after the judge advocate is named to act at the trial, entitled to his opinion on any question of law or procedure relative to the charge or trial, whether he is in or out of court. And the accused and his lawyer, that's what it means. So any legal issues arising, I am mandated to advise this court. To begin with, holding this court a tribunal, that one will not happen. The UPDF Act defines court-martial as field court-martial, general court-martial, or court-martial appeal court. That is what a court-martial is. Even in the Constitution, it is there that you can, the DPP can have superintendent over all proceedings apart from the court-martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court martial. That is the name that is in the UPDF Act. We are not going to adapt dictionary definitions. Secondly, the issue of Aaron Kizza as one of the lawyers. I also direct you to read Article 28, Clause 3, Clause 3. Sometimes I never to read because when I refer to read, they say I should read. So I will read. It says every person who is right, that's the right to a fair hearing, every person who is charged with a criminal offense shall, when you go to be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled it. However, gravity of the offense, you cannot say that when we have 30 lawyers here, Aaron Kizza, who was convicted by this court, is not there, and therefore the right to fair hearing is violated. Then what would be your role here? All the lawyers who are here, if I may ask. Or can I say you are going to say it's a constitutional violation because a person who was convicted before this court is not there and all the over 30 lawyers are here, that the right to doctor is violated? My answer is no. And if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but to say you can be 30 and Kizza has a specific role, to me that doesn't make sense. I think I've done with that. About the environment not being conducive, the person raising this matter is ably submitting before this court. How can you say the environment is not conducive when you are saying all what you have said? Council Kwabo, for me, I don't understand what you are saying. Then, the issue of court members, when we started this session, all court members, including those in the reserve, were present, and all of the members before you have been following this case, have been in court. So the fact that you are seeing one is not there, whoever is there has been here or from day one when this court started. So you cannot say that these are new members, we have an instrument appointing the members. You can cross-check. They are there and they have never missed any session when we are sitting. So there is nothing that members are changing without notice. That one also has not happened. The other aspect, I think the last one, I think the one raised by Council Bang, I will not go into it because I have already given my position. But Senior Council Karua said that me, as a brigadier to Kachungu, I called you that you are a foreigner. I have to ask you, if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you apologize for saying I said you called you a foreigner. We have interacted, but it has never come out of my mouth. That is my response.
May I, Mr. Chairman, remind my learned friend here that it is actually on video. You refer to me as a foreigner.
You bring it.
And everybody remembers it has caused a lot of heat on social media.
No, bring it. But I never said so.
My question is, the court members, we are ready to proceed. This case was... Which court has not pronounced itself? Which one? The proprietary of the proceedings where the pan has been shifted.
That's what he was explaining about. That's what
he was advising the court. It's not that, it's not, he was advising who to take a procedure.
Council can see them also. This is an issue that we have. Can you say also?
It's like this council of members of this court.
I can even reply, I think I didn't address that one. But if court pronounced itself on the matter, if you feel that you have proof that the court was not fully constituted, you have an avenue of appealing and challenging the decision of that court. But you cannot raise it here that court is going to pronounce itself. Court was properly constituted, it took a decision. Now, for you who is aggrieved and saying no, then we have a commercial appeal court. Appeal with proof. They will give you an answer.
Would you therefore kindly give us a list of those who sat at the sentencing session for Aaron Kizza, because we noticed there was a change. If you gave us that, it will help us in the appeal you have directed us to, because we definitely will take up the issue. But there is also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at, we have looked at the Uganda, Constitution of Uganda, Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this General Court-Martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government, only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, interpretation of that. We also want the interpretation of the fact that lawyer, what do we mean by lawyer of choice? And by arresting and sentencing Aaron Kizza when he is in court as an advocate, and the issue was a success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. Has that interfered with the right to representation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like referred, and which we are going to draw your attention. If I may, I want to go over 2 or 3 of them and ask my colleagues to supplement. The first one I have indicated. You asked us to refer matters of interpretation to the Constitutional Court, and I am now seeking a reference to the Constitutional Court.
Madam Chairman, what Senior colleague is referring to, Madam Chairman, I think she will need to address herself on the procedure, especially on references under our rules Constitutional Court petition and its rules. And I don't think by submitting that she's seeking a reference from this court, that's what the rules provide. It doesn't provide that. There is a procedure that is provided for under those rules. Therefore, my Lord Chairman, I pray that we proceed with what the merits of the case are, instead of going against what the rules of reference provide. Myself.
And maybe, sir, on the question of whatever you have raised, I have responded. So I don't see how you open again. The question of jurisdiction was the first thing we dealt with when, before I took even a plea, and the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved. As I read to you, regarding advising on legal matters, I have given my advice. So I beg you to proceed to the chair. Maybe Council Kwago was calling you, my lord, chairman. Nobody has forced you to say my lord. Even if you say honorable chairman, it's okay. But even if you say my lord, that's upon you. You cannot start challenging him that those calling you. He has not requested anybody that call me my lord. You can call him honorable chair of the court. It's okay. So I don't think even it's the question worth asking him that he respond. There's nothing to respond there.
Mr. Chairman, just before my senior colleagues come, again, just for consistency, we kindly request.
Council, let's not repeat what have been said and answered.
I'm not going to repeat it, Mr. Chairman.
Yes.
I'm only asking that because we are many, if we can kindly follow a process whereby if a matter is raised with the Honorable Court, we understand that the role of our colleague is to advise. So we take it that when advice is issued by the judge advocate, the matter then returns to the court to make a finding so that the matter either rests or is left pending. And why we are saying so, Mr. Chairman, for example, is that there was no finality. Before I say that, otherwise, Mr. Chairman, it will appear then that if an issue is raised by counsel and the judge advocate issues advice, and the court does nothing after that advice, then it means that the court is bound and subject and subordinate to the judge advocate. Why am I raising this? Otherwise, my lord, there appears to be a difference between counsel and the judge advocate. Regarding the issues raised in housekeeping, there has been no adverse position from the state. In the other setup where we work, when you don't refute, you accept. And it will appear then that the judge advocate is either coming into the realm of the state and also taking over the realm of the court. Why am I saying so, Mr. Chairman? There was an issue regarding the composition of the panel. And we take it, Mr. Chairman, that all the honorable members of the panel are part of the decision-making process of this court. The benefit we have is that when all of them are present, it is possible to follow the events, to look at witnesses, and come to an agreement. It would be unfair to Mr. Kalibala, for example, if he laid his evidence before me and then he's cross-examined before Mr. Chiwanuka, and then the decision is made by Mr. Rukwa. There is a break in the chain. So we kindly ask, before we go any further, Mr. Chair, that the issue of the panel is completed. My neighbors whispered, and I'm sorry if they are wrong, that at the last sitting, your neighbor to my right exactly was not on the panel. I don't know why any particular member here identified only her, I don't know, but they insist that she was not on the panel. Other members before have said that there was one lady, now there are two. I think that causes a concern and may go back. So it raises an issue that if we break the consistency of the panel which constitutes the court, then the judge has advised that they are following, they may be following from somewhere, we don't see them here, but we bear in mind that the interests we are representing are for the persons, that they themselves, no matter the decision of the court, must be satisfied that the process has been fair and has played in accordance with the rules. So, Mr. Chairman, if the rules say that the members should be here, I think it's good that they are here. So that, and I think that's a simple matter. If they say the reserved members are here, I don't direct, but perhaps the court can get a center so that we are happy that they are there and we see them. I think that will solve that issue. So I request, Mr. Chair, before, and maybe we first state the issue of the reference, that we put to finality the issue of the panel. Because again, if we make submissions regarding whatever I want to say, and the court has to retreat, or the state has to ask for a time to consider, and the next panel is not the same, we will then have to make the same submissions just so that the person making the decision hears us out. So I would like to request, Mr. Chair.
Mr. Chairman, on the same, my whisper was not quoted by him. I didn't want to stand again. I wanted to bring it to his attention that actually the neighbor does not have a name tag, just like the others. That was our observation, and it needs to be clarified. Secondly, I think my issue of parking includes access, my access as council, access in court. I'll be on record, I'll not come back to this court if I'm parking 1 kilometer away. Access includes me parking within the premises. I think that needs to be also clarified by this court. We need a conducive environment as council that is persons. I'll not carry a box of books like I did today, a kilometer away from here, Mr. Chair.
I'm sorry, my neighbor is killing me. He says they say I should insist that the person who was sitting to your right the other day, in their view, appeared to be a gentleman. They alleged it is a name of Kalepo, and the collar was red. So we don't know whether so we don't know whether the person there has lost red, but as you can see, maybe it's a concern that the people hearing us out, when they are changing, there's a concern that may not be had fair and square. It's our polite request, Mr. Chair, that the court makes a pronouncement before we go further regarding the consistency of the tribunal, of the panel constituting the court. I'm sorry, of the panel constituting this honorable court.
It is all right, Council. Yes, the other day there was a Kano here, as you have said, Kano Kalepo. But as you heard from Judge Advocate, we are 19 members. 27 are supposed to be here, including me. And then the reserve is supposed to be behind there, so I said, but maybe some would have misplaced by you. But you. I can see is that when the case one maybe have a problem of fees, he can go out another one coming. That's how we usually operate.
unless you will add on something, but that's how we operate. Let me, accessing the court, Council, I may answer maybe from the gate here, around this premise and inside here, but outside the premise, I mean the gate, I may not have an adequate answer for that. And
I think so what I can inform the lawyers is that this part of the court is consistent of composed of 7 members before it can conduct business and in a case of capital nation. We have 7. There is now no case arising before this court where Major Saga was not present. So we are ready for today's session.
We need to put this in context. The spirit of the rule that requires that the name be declared at the commencement of the proceedings. The spirit is very clear. And actually it does not stop there. It requires that if there are objections to any of the members, the accused persons are at liberty to say so. So if the panel keeps standing like we have told Captain Okalebo, Kano came in just to replace the one who had been on record before without any procedure being followed. That goes to the root of the proceedings, the validity of the proceedings. That have not had the pronouncement of the court martial, the validity of the proceedings, because it was not done at that on the day. Actually, Kizza was summarily tried and convicted when Captain Okalebo came in. Kano Okalebo came in, sorry. When Kano Okalebo came in, there was no declaration made. And I've not had any pronouncement on the validity of the proceedings which were conducted in outright violation of the regulation that requires that you make a declaration that this is the tribunal that is going to try you. So this is the whole point we are making, Mr. Chairman. So if Mr. Chairman will continue operating like this, then it's a negation of not only the spirit of the Act and the regulation, but the Constitution itself. Which Constitution is what is establishing this very court martial. So, Mr. Chairman, we need, like, in reinforcing the submission of my grand friend, Freddy Park, let the court make a pronouncement, a decision.
Council, the culture here is, once an chosen person is brought in the docker for the first time, he is introduced to all members here and the members, which was done on that day. So this, our changing of position or alteration, just is when we are proceeding. Or maybe, unless you are asking that, where is Okalebo now? That's what you are asking.
Not only that, the validity of the proceedings, the legality of the proceedings, where a member of the panel is not introduced because Captain Kano Okalebo was never introduced to the accused person. This is the point. All the accused persons, these ones in the dock and the Eroniches, because he was also put in the dock here briefly. So Okalebo was never introduced to the accused person.
I think you could have forgotten, but that is the thing that is done on the first day when the accused persons or persons appear in the dock. And they are asked, and they answered. They had no objection.
And maybe, sir, for Kizza, let me educate the council power. On contempt of court, you cannot say that Kizza was supposed to take a plea, he was supposed to be defended. There is nothing like that when you are in contempt of court. Contempt of court, you must understand about how it is, the whole process works. So you cannot say that the panel was not introduced to him. Those procedures don't apply
think you need to close the chapter of Kizza because he was convicted and sentenced. If you are not satisfied, you know what to do. That one. I think let us proceed.
He's still on the pan of the lawyers.
So should we adjourn up to his finishes his sentence?
The guidance we are seeking for Mr. Chairman. How do we deal with this?
About
the instructions.
About the convict, the one who is sentenced, who is serving the sentence.
But he still has instructions, Mr.
So which
Chairman.
means all of you cannot proceed.
I think it is very important what the judge advocate is giving us advice to this court. And I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this court will be very important, and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are restricted to side with the judge advocate, or for good reason to differ with him, because we are objecting also based on law, so that you are given the correct procedure. What happened to Aaron Pastor happened, and he is going to take action accordingly. But if moving forward, the proper procedure is not applied, then we are at risk. That's what we are saying.
I think so. We move forward. Mr. Chairman, we close the chapter. All matters are.
No, we are closing the chapter. But what I want to tell the defense attorneys is that just feel free, unless you conduct yourself in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are held responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Mr. Chairman, allow me the latitude, Mr. Chairman. On the issue yes, much obliged, Mr. Chairman. On the issue of changing the panel, Mr. Chairman, it has far-reaching consequences. For instance, well, when the ruling which resulted in sentencing my land friend Aaron Kizza was being read, reference was made to his earlier conduct in 2024. But Colonel Okarebu was not present in 2024. However, he participated in sentencing Aaron Kizza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
So I think you need to give them the list. They are an instrument of ours so that they understand the condition of this court.
Whoever wants, we have our one register there. And they are also advocates. They are there, they are seated. Don't just think they are clerks. The major and the one next, they are also advocates. They manage our registry, which is also under my office. So you can ask anything. If it is an instrument of appointment, they have it.
Go ahead, go with this state.
Mr. Chairman, just the last one, the very last one, and it touches me personally. Mr. Chairman, it touches me. Mr. Chairman, it touches me. Mr. Chairman, I beg, Mr. Chairman, your indulgence, Mr. Chairman, I thank you. This is the very last one, Mr. Chairman, which you raised in your communication, Mr. Chairman. Mr. Chairman, if I may be permitted, Mr. Chairman. Mr. Chairman, I beg for your indulgence.
Cannot speak at the same time.
I am seeking for the indulgence of the chairman.
He has not
It's a humble, I know, and
This is what we are saying now. Because if you are to conduct ourselves like that, then we may not go anywhere.
Because, Mr. Chairman, we are dealing with matters of life and death.
Since we started, we are talking. Let's see.
Mr. Chairman, it all depends on the gravity of the matters we are dealing with. The sentence we are talking about here is death.
Chairman,
the charges is death.
I suggest you rail on Council Kwabo, you should respect the chair and vote. Two lawyers cannot speak at the same time when you are all standing. It's very honest.
Councillor Faye, proceed.
On the 7th of January, when this matter came before the court, I included this talk that we intend to amend the charge sheet. But because of some administrative matters, we could not proceed which happened in court. So, Chairman and court members, we want to amend the charge sheet and we are amending the discharge sheet pursuant to Regulation 66 of the Uganda People's Defense Forces Rules of Procedure. It is premised on the need to ensure that justice is effectively administered by holding all parties accountable. So during the course of investigations, some facts revealed that there is a serving UPDF officer who is connected to the offense. So we intend to have the charge sheet amended by addition of that officer. And we also intend to amend the charge sheet by adding there another count of treachery. So those are the two amendments we are seeking to amend. The person who is introduced on the charge sheet is RO 743, Captain Dennis Ora. The male adult Ugandan, a soldier of regular forces of Uganda People's Defense Forces. And he is attached to Armored Brigade.
Chairman, I beg permission, sorry, beg pardon for the particulars of sorry,
So is RO 74 3. Captain Dennis Ola. Is an officer attached to Armored Brigade. And we are also adding there the count of treachery, which will be count 2. Including the officer and the 2 accused persons. Those are the amendments we seek to have.
We object to the amendment, especially before the ruling of jurisdiction. In fact, we stopped the application for reference to await the ruling on jurisdiction. We feel that amending to add a person who is serving in the military is meant to preempt the ruling on jurisdiction. Because the court has no, it's in our view that the court has no jurisdiction on these two gentlemen, and we see that the ruling precedes the amendment of the charges. When we then can raise full objection, because the charges, the amendment is not sought properly pursuant to the rules of procedure. Any colleague?
Council, which ruling are you talking about? Which ruling are you talking about?
On the ruling that you referred to Mr. Ukwago having argued on your jurisdiction to trial. There is a ruling you've been seeking to deliver ever since we came.
From the Supreme Court?
From yourselves. From this court martial.
That was not the first.
Mr. Chairman, we have been under the impression that there is a rule on several occasions that was supposed to be delivered. And that ruling relates to matters that were raised the first time the accused persons were charged. That matter, I think, has something to do with jurisdiction. It has something to do with the extraterritoriality of some of the offences and how we got here, and therefore it's applies to the charges. So we have all along been under the impression that there is in fact a ruling. I do recall my land friend of fire once actually rose and said we are ready to listen. But the events that have taken place since that time have not made that far. So we are keen on receiving the ruling. Mr. Chairman, that is point number one. Point number two, it relates to what the Madam Treasurer has just prayed about, the amendment of charges. I am looking at the rule that was cited on amendment, and it talks about amending charges where there is a mistake in the name or description of the accused, or a mistake which is attributable to clerical error or omission. And he did say that in the charge there have been reference to a serving officer. I haven't seen that reference myself in the charge, but I don't think that calling somebody a serving officer is a clerical error or omission, so that now we have found the name. You must have known the name, but just refused to put it there. So I'm not sure that that regulation 66 allows him to do what he's asking, than to join Captain Davis. So I just rise on those two issues. The ruling, then required to what another is asking.
Mr. Chairman, for the record, Blowing Bazina Recall, I associate myself with submissions of my senior land friends. Mr. Chairman, the move by the prosecution is a calculated way of defeating the defense which has already been brought to your attention through preliminary objections raised by my senior land friend, Counsel Elias Lukwago, when he objected the jurisdiction of this court. And indeed, there is a pending ruling The other time when Senior Counsel Martha Karua came, we were not allowed to proceed with receiving that ruling, awaiting the grant of a temporary practicing certificate to Senior Counsel. Indeed, Mr. Chairman, there is a ruling pending before this court, and the prosecution is trying to, yes, if the prosecution refers to the notes they've been taking, they realize that indeed when we compare the same with ours, there is a pending ruling and they intend to preempt the ruling, Mr. Chairman. Don't allow them, they will be defeated. Yes.
Mr. Chair, just for recollection, you may be recalled when Senior Colleague Martha Karua, the first chair, raised an application for an adjournment for an hour. And court wasn't ready. Court graciously granted us 15 minutes. At that time, the business of the court before the adjournment was to deliver a ruling regarding matters raised by Mr. Elias Mpango. That was overtaken by events because when we came back in the afternoon, we did indicate to court that there were issues regarding instructions to receive the ruling and also the matter of Mr. Kizza. So it is correct, if I recall, that it was at my request that we were granting an adjournment of 15 minutes so that we come back and issue the ruling was in the House. Perhaps, Mr. Chairman, it may be necessary for court to retreat for 10 minutes just to confirm that it is correct that there was a pending ruling with regard to what was issued by the Mr. Thank you, Mr. Chairman.
Council understand that when the declaration is 66, 1, but we do not proceed to paragraph 2, which states at any time during the month at which there is a judgment, it appears to court before it closes the deliberating its finding that it is desirable in the interest of justice to make any addition or omission. So that is the addition. I'm moving on to that. So the addition I'm adding there, because this is during the course of investigations, the additional evidence was brought and the person is magic, and also another count is also added. In regard to the ruling, we are also expecting the ruling.
Mr. Chairman, just a brief to join up Rule 66. I had read Sub-Rule 2, but my interpretation of Sub-Rule 2 suggested that it only applies when we are at a stage when the court is closing to deliberate on its findings. We are still at the initial stages of this matter. So I still submit that neither to the can't proceed under this 66. 66(1) doesn't help him. 66(2) certainly destroys his address.
Allow me, Mr. Chairman, to add just one thing.
They have four workers.
We are relying on a matter of law to your application. Actually, the rules are so strict that once you charge an accused person, other than errors in name and at the stage of deliberation to make a conclusion, where the evidence may have revealed a different charge, you cannot add other accused persons. That's our reading of that particular regulation, Regulation 66, 1 and 2, and we are asking you to make a finding that they cannot amend at this stage. I want to thank the prosecutor for admitting that indeed we expect a ruling from the court on the agenda.
The court is adjourned for 10 minutes.
We're going to